Hello! Welcome to the Study With Me series of Law School Buddy. I have prepared audiobook materials following the syllabus of the Philippine bar exams dedicated to our law school students. I hope that this audiobook can help with your study and review. Let's begin. This episode will cover Property Law, Title 7, Easements of Servitudes, Chapter 2, Legal Easements, Section 1, General Provisions, Article 634. Easements imposed by law have for their object either public use or the interest of private persons. Article 635. All matters concerning easements, established for public or communal use, shall be governed by the special laws and regulations relating thereto, and in the absence thereof, by the provisions of this title. Article 636. Easements established by law, in the interest of private persons, or for private use, shall be governed by the provisions of this title, without prejudice to the provisions of general or local laws and ordinances, for the general welfare. These easements may be modified, by agreement of the interested parties, whenever the law does not prohibit it, or no injury is suffered by a third person. Section 2. Easements relating to waters. Article 637. Lower estates are obliged to receive the waters, which naturally and without the intervention of man, descend from the higher estates, as well as the stones or earth, which they carry with them. The owner of the lower estate cannot construct works which will impede this easement, neither can the owner of the higher estate make works which will increase the burden. Article 638. The banks of rivers and streams, even in case they are of private ownership, are subject throughout their entire length, and within a zone of 3 meters along their margins, to the easement of public use, in the general interest of navigation, floatage, fishing and salvage. Estates adjoining the banks of navigable or floatable rivers are furthermore subject to the easement of towpath, for the exclusive service of river navigation and floatage. If it be necessary for such purpose, to occupy lands of private ownership, the proper indemnity shall first be paid. Article 639. Whenever for the diversion or taking of water from a river or brook, or for the use of any other continuous or discontinuous stream, it should be necessary to build a dam, and the person who is to construct it is not the owner of the banks, or lands which must support it, he may establish the easement of abutment of a dam, after payment of the proper indemnity. Article 640. Compulsory easements for drawing water, or for watering animals, can be imposed only for reasons of public use, in favor of a town or village, after payment of the proper indemnity. Article 641. Easements for drawing water, and for watering animals, carry with them the obligation of the owners of the servient estates, to allow passage to persons and animals, to the place where such easements are to be used, and the indemnity shall include the service. Article 642. Any person who may wish to use, upon his own estate, any water of which he can dispose, shall have the right to make it flow through the intervening estates, with the obligation to indemnify their owners, as well as the owners of the lower estates, upon which the waters may filter or descend. Article 643. One desiring to make use of the right granted in the preceding article is obliged 1. To prove that he can dispose of the water, and that it is sufficient for the use for which it is intended. 2. To show that the proposed right-of-way is the most convenient and the least onerous to third persons. 3. To indemnify the owner of the servient estate in the manner determined by the laws and regulations. Article 644. The easement of aqueduct for private interest cannot be imposed on buildings, courtyards, annexes, or outhouses, or on orchards, or gardens already existing. Article 645. The easement of aqueduct does not prevent the owner of the servient estate from closing or fencing it, or from building over the aqueduct, in such manner as not to cause the latter any damage, or render necessary repairs and cleanings impossible. Article 646. For legal purposes, the easement of aqueduct shall be considered as continuous and apparent, even though the flow of the water may not be continuous, or its use depends upon the needs of the dominant estate. or upon a schedule of alternate days or hours. Article 647. One who for the purpose of irrigating or improving his estate has to construct a stop-lock or sluice gate in the bed of the stream, from which the water is to be taken, may demand that the owners of the banks permit its construction. After payment of damages, including those caused by the new easement, to such owners and to the other irrigators. Article 648. The establishment, extent, form and conditions of the servitudes of waters, to which this section refers, shall be governed by the special laws relating thereto insofar as no provision therefore is made in this code. Section 3. Easement of right-of-way. Article 649. The owner, or any person who by virtue of a real right, may cultivate or use any immovable, which is surrounded by other immovables, pertaining to other persons, and without adequate outlet to a public highway, is entitled to demand a right-of-way through the neighboring estates, after payment of the proper indemnity. Should this easement be established in such a manner that its use may be continuous for all the needs of the dominant estate, establishing a permanent passage, the indemnity shall consist of the value of the land occupied and the amount of the damage caused to the servant estate. In case the right-of-way is limited to the necessary passage for the cultivation of the estate surrounded by others, and for the gathering of its crops, through the servant estate without a permanent way, the indemnity shall consist in the payment of the damage caused by such encumbrance. This easement is not compulsory if the isolation of the immovable is due to the proprietor's own acts. Article 650. The easement of right-of-way shall be established at the point least prejudicial to the servant estate, and insofar as consistent with this rule, or the distance from the dominant estate to a public highway may be the shortest. Article 651. The width of the easement of right-of-way shall be that which is sufficient for the needs of the dominant estate, and may accordingly be changed from time to time. Article 652. Whenever a piece of land acquired by sale, exchange or partition is surrounded by other estates of the vendor, exchanger, or co-owner, he shall be obliged to grant a right-of-way without indemnity. In case of a simple donation, the donor shall be indemnified by the donee for the establishment of the right-of-way. Article 653. In the case of the preceding article, if it is the land of the grantor that becomes isolated, he may demand a right-of-way after paying an indemnity. However, the donor shall not be liable for indemnity. Article 654. If the right-of-way is permanent, the necessary repairs shall be made by the owner of the dominant estate. A proportionate share of the taxes shall be reimbursed by said owner to the proprietor of the servant estate. Article 655. If the right-of-way granted to a surrounded estate ceases to be necessary because its owner has joined it to another, abutting on a public road, the owner of the servant estate may demand that the easement be extinguished, returning what he may have received by way of indemnity. The interest on the indemnity shall be deemed to be in payment of rent for the use of the easement. The same rule shall be applied in case a new road is opened, giving access to the isolated estate. In both cases, the public highway must substantially meet the needs of the dominant estate in order that the easement may be extinguished. Article 656. If it be indispensable for the construction, repair, improvement, alteration or beautification of a building, to carry materials through the estate of another, or to raise or scaffolding or other objects necessary for the work, the owner of such estate shall be obliged to permit the act after receiving payment of the proper indemnity for the damage caused him. Article 657. Easements of the right-of-way for the passage of livestock known as animal path, animal trail or any other, and those for watering places, resting places and animal folds, shall be governed by the ordinances and regulations relating thereto, and in the absence thereof, by the usages and customs of the place. Without prejudice to rights legally acquired, the animal path shall not exceed in any case the width of 75 meters, and the animal trail that of 37 meters, and 50 centimeters. Whenever it is necessary to establish a compulsory easement of the right-of-way, or for a watering place for animals, the provisions of this section and those of Articles 640 and 641 shall be observed. In this case, the width shall not exceed 10 meters. And that is the end. If this audiobook has helped you, please comment down below and like and share our video to someone who might need it. Thank you so much for making us your law school buddy.